Hello everyone, my name is Jonathan Williams, and this is my narrated PowerPoint presentation over the important equal employment opportunity laws. This is an outline of the important equal opportunity laws we are going to cover. The Equal Pay Act of 1963, Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act of 1967, Vocational Rehabilitation Act of 1973, Pregnancy Discrimination Act of 1978, the Civil Rights Act of 1991, the Americans with Disabilities Act of 1990, and the ADA Amendments Act of 2000. The Equal Pay Act of 1963 was amended by Congress in 1972. The Equal Pay Act makes it unlawful for employers to discriminate in pay based on gender or sex when the job involves the equal amount of work, effort, skills, or responsibility, and the job is done under the same or similar conditions. However, with that being said, a difference in pay does not violate the Equal Pay Act if the difference in pay is based on seniority or a merit system. Title VII of the 1964 Civil Rights Act was amended by the 1972 Equal Employment Opportunities Act, which states that an employer cannot discriminate based on race, color, religion, sex, or national origin. It makes it unlawful for an employer to fail or refuse to hire or discharge an employee with respect to their compensation, terms, conditions, or privileges of employment. It also makes it unlawful for employers to limit, segregate, or classify their employees or applicants in a way that it might deprive them of an individual employment opportunity or have an effect on their status as an employee. It is thanks to this Civil Rights Act that the Equal Employment Opportunity Commission was established. The EEOC is a group of 5 members who are appointed by the President to oversee thousands of employees whom assist in the administering of the civil rights law in employment settings. Establishing this committee has helped our government to better enforce our equal opportunity employment laws tremendously. The Age Discrimination in Employment Act of 1967 makes it unlawful for employers to discriminate against applicants or employees if they are 40 years of age or older, which in turn put an end to most mandatory retirements. In the O'Connor versus Consolidated Coin Caterers Corporation case, the United States Supreme Court ruled that it is unlawful for employers to replace employees over 40 years of age with employees that are significantly younger but are still 40 years of age or older. A good example of this would be an employer replacing all of their employees who are 60 years of age or older with employees who are in their early 40s. The Vocational Rehabilitation Act of 1973 requires employers who have federal contracts over $2,500 to take affirmative action for the employment of disabled people. Under this act, employers are required to take the necessary steps to help accommodate disabled workers unless doing so imposes an undue hardship on the business. However, employers are not required to hire unqualified people. The Pregnancy Discrimination Act of 1978 prohibits the using of pregnancy, childbirth, or related medical conditions for discrimination in hiring, promoting, discharging, or any other term or condition of employment. If an employer offers disability coverage to its employees, then they must treat pregnancy and childbirth as a disability as well. The Civil Rights Act of 1991 addresses the issue of burden of proof by a process of filing and responding to discrimination charges. One must not prove discriminatory intent, but they must prove an employment activity causing them disparity is job-related. This act also makes it much easier for employees to sue for money because it claims any employee who is claiming desperate treatment or intentional discrimination has the right to request for compensatory or punitive damages if they can prove their employer discriminated toward them with malice or indifference to the federally protected rights of an aggrieved individual. The Act also addresses mixed motive cases. Mixed motive cases are cases where the employer claims, although their actions may have been discriminatory, there were other factors that made their force of action acceptable. Employers must be able to prove the employee's inability to complete an everyday job-related task is causing them a hardship. An example of this would be an employee's inability to lift 100 pounds on a regular basis. A possible factor an employee might use to justify their force of action might be an employee's lack of performance. The Americans with Disabilities Act of 1990, also known as ADA. ADA prohibits employers with 15 or more employees from discriminating against qualified individuals with disabilities with regard to hiring, discharge, compensation, advancement, training, or other terms, conditions, or privileges of employment. Qualified individuals can be defined as anyone who can carry out the essential functions of the job requiring a reasonable amount of or no accommodations. ADA requires that employees take the proper steps to make reasonable accommodations for those who are disabled unless it imposes an undue hardship on the company. Examples of reasonable accommodations include, but are not limited to, redesigning the job, modifying work equipment, and maybe modifying the work schedule. The Act doesn't, however, list specific disabilities. According to EEOC guidelines, in order for someone to be considered disabled, they have to have a physical or mental impairment that substantially limits one or more major life activities. These impairments include any psychological disorder or condition, cosmetic disfigurement, or anatomical loss of one or more of several body systems, or any mental or psychological disorder. Conditions it doesn't consider disabilities are homosexuality, bisexuality, voyeurism, compulsive gambling, pyromania, and any disorders that come as a result of illegal drug use. The ADA does, however, prevent discrimination against individuals with HIV or AIDS. The ADA Amendments Act of 2008, also known as ADAAA, makes it much easier for employees to prove their disabilities are limiting to their major life activities because they have now broadened the list of activities they consider to be major life activities to include reading, concentrating, thinking, sleeping, and communicating. It is under the ADA Amendments Act, employees will be considered disabled even if they are able to control their physical or mental impairments through medical or learned behavior modifications. Equal employment opportunity laws play a huge role in the business world, and since the early 1960s, a variety of equal employment opportunity laws have been established to help protect the individual's rights as an employee. One should not be discriminated against based on their race, color, age, sex, or their national origin. These laws play an important role in the diversity of our workforce because they make it possible for everyone to be treated equally, and they even give those with disabilities the opportunity to be accepted into a working environment. This is why equal employment laws are so important, and managers should be extremely familiar with them to make sure their business is operating in compliance with them all.